This morning, at precisely 10:30 a.m. Eastern Time, the Supreme Court of the United States issued a brief yet decisive ruling. The justices denied an application in a significant legal case. All 9 justices were in full agreement, no one dissented, and no separate opinions were filed. The entire decision consisted of just 2 words: application denied. That single sentence brought months of intense legal battles to a close. This ruling arrived exactly 72 hours after Melania Trump's lawyers submitted a special agreement to federal prosecutors. In that agreement, she detailed the evidence she was prepared to provide in exchange for potential immunity from prosecution. 2 major legal developments unfolded just 3 days apart, and their timing strongly indicates a close connection. Before anyone brushes this off as rumor or sensationalized reporting, rest assured, everything discussed here stems from official court filings, formal agreements, and Supreme Court orders. These are all publicly accessible records, not anonymous sources or hidden leaks. Anyone can search and confirm them directly. Here is what has now become legally established. If you're following this rapidly evolving case and want more timely legal breakdowns like this one, please hit that subscribe button right now and enable notifications. You won't want to miss what unfolds next. Melania Trump has voluntarily waived her spousal privilege. This legal safeguard typically prevents prosecutors from forcing one spouse to testify against the other. She chose to relinquish it willingly. The evidence she is offering falls into 3 key categories. First, financial documents that reportedly demonstrate her awareness of inaccurate property valuations. Second, various communications, including conversations about property values and loan-related paperwork. Third, her own testimony as a witness, which will corroborate statements accountants and bankers have already provided under oath to the grand jury. With the Supreme Court rejecting the final appeal, every possible legal avenue to halt this has been exhausted. No further appeals can be filed, no delays remain, and no procedural maneuvers are left. The grand jury can now hear her testimony in a matter of days. Adding to the pressure, her former husband's confirmation hearing for a cabinet position is scheduled for early March, only about 6 weeks away. Here is precisely how events unfolded over those critical 72 hours, and the sequence was far from coincidental. On Monday afternoon at 2 p.m. Eastern, Melania Trump's attorney submitted a document to the special counsel's office known as a proffer agreement. In straightforward terms, a proffer acts as a preview. The witness shares what they know, what they are prepared to testify to under oath, and what evidence they can provide. In exchange, prosecutors evaluate whether to grant immunity, protection from charges tied to that testimony. This is a standard practice in federal investigations. What sets this case apart is the identity of the witness and the gravity of what she is prepared to share. On Tuesday afternoon at 2 p.m. Eastern, exactly 24 hours later, the defendant's legal team filed an emergency appeal with the Supreme Court. Things just became even more intense. What's running through your mind right now? Drop your honest thoughts in the comments below. Could this be the breakthrough moment we've awaited? I'm responding to as many as possible. Let's discuss it together. They sought to block her testimony before the grand jury could hear it, arguing that a spouse's testimony would violate marital privacy protections under the Fifth Amendment. Preparing and filing an emergency appeal in only 24 hours is remarkably swift. Most such appeals require weeks of preparation. This speed strongly suggests the defense team anticipated this development and had already prepared their response. On Wednesday morning, the Supreme Court officially docketed the appeal, assigning it a case number and placing it on their review calendar. Crucially, however, they issued no stay. A stay would have paused all proceedings while the court deliberated. Without one, the legal process continued unabated during their consideration. This absence of immediate intervention carries real weight. When the Supreme Court grants a stay right away, it often signals that the justices see potential merit in the claim. When they allow matters to proceed without pausing, it typically reflects skepticism about the argument's strength. Then, this morning, Thursday, at 10:30 a.m., the Supreme Court delivered its definitive answer in one concise sentence: application denied. No dissents from any justice. Justice Thomas raised no objection. Justice Alito raised no objection. Justices Gorsuch, Kavanaugh, and Barrett, each appointed by Trump, joined in full agreement. It was a complete unanimous rejection. When the court issues even a short opinion, it usually means the legal issue warranted some clarification. But a single-sentence denial with zero disagreement signals that the appeal lacked sufficient substance to merit discussion. In more than 30 years of closely following legal developments, I've seen this level of outright dismissal only a handful of times, and each instance involved an argument so fundamentally weak that the court deemed it unworthy of further explanation. So that completes the full 72-hour timeline. The proffer filed on Monday, the emergency appeal submitted on Tuesday, the court receiving it without halting proceedings on Wednesday, and the application denied on Thursday. Now, let's examine what is actually contained in the proffer agreement, because the evidence she is providing carries far greater significance than many headlines imply. The agreement outlines 3 categories of evidence. The first involves financial documents indicating she knew about dishonest property valuations. She signed joint tax returns from 2014 to 2020, 6 consecutive years of filings where both spouses certify under penalty of perjury that the financial details are accurate. Those returns rely heavily on asset valuations, what properties are worth, the income they generate, and the deductions claimed. If values were inflated when presented to banks for loans, but deflated when reported to tax authorities to reduce tax liability, that constitutes both bank fraud and tax fraud. Signing a joint return exposes both parties to potential legal consequences. The proffer further notes that she attended meetings with accountants where asset values were discussed, even raising questions about how properties were being reported. All of this is supported by emails already in prosecutors' possession. The second category covers communications. This includes text messages exchanged with the defendant about property values ahead of lender meetings. It also includes emails with accountants in which she questioned discrepancies between figures presented to banks and those reported to tax authorities. Additionally, there are recorded phone conversations in which specific property values were discussed in connection with loan applications. In federal cases, if she recorded those conversations in compliance with consent laws, the recordings can serve as powerful evidence. Since she is offering them in her proffer, prosecutors have already thoroughly verified their authenticity. The third category is witness corroboration. She can confirm the accounts that accountants previously provided to the grand jury. She can support the sworn statements made by bankers. She can reinforce what property appraisers described about being pressured to inflate property values beyond their true worth. In federal prosecutions, corroboration carries tremendous weight. When one witness testifies that they were present in a meeting where dishonest valuations were discussed, that testimony stands strong. When a second witness confirms they were in the same meeting and verifies what was said, the evidence grows much stronger. And when a third witness brings forth documents from that very meeting, revealing the inflated values, it establishes a compelling pattern of proof that becomes extremely difficult for any defense to rebut. The most stunning legal development hidden within this proffer is that she is waiving spousal privilege. In most situations, a spouse cannot be compelled to testify against their partner. This safeguard exists because the law values the trust essential to marriage and seeks to protect it from being shattered by forced testimony. Yet spousal privilege can be relinquished voluntarily. Her proffer agreement explicitly states that the privilege is waived for all matters addressed in the agreement. This is not a case of prosecutors compelling her cooperation. It is her own deliberate choice to step forward and cooperate. Spousal cooperation has occurred before, such as in organized crime cases where wives of mob figures testified to safeguard themselves, or in corporate fraud prosecutions where spouses of executives cooperated after recognizing their shared legal exposure. However, this marks the first time at such a high level, where the defendant previously occupied the nation's highest office, that a spouse has voluntarily provided financial records, communications, and direct testimony. The defendant's emergency appeal to the Supreme Court presented 3 primary legal arguments, and all 3 were rejected. Loving how this case continues to unfold. What's your reaction right now? Drop a comment below. Agree, disagree, shocked, or something else? Your thoughts always enrich the discussion. Hit that comment button. The first argument claimed that spousal testimony violates marital privacy protections under the Fifth Amendment, yet more than 150 years of Supreme Court precedent affirm that spousal privilege can be voluntarily waived. The landmark case, Trammell v. United States from 1980, established that the witness spouse holds control over the privilege. This means the choice to testify rests with the witness, not the defendant. If the witness elects to waive the privilege and testify, the defendant has no power to prevent it. That decision has never been overturned, and every federal circuit court across the nation adheres to it. Consequently, this argument lacked any solid legal foundation. The second argument asserted that the proffer agreement was secured through force, threats, or prosecutorial pressure, rendering the testimony involuntary. However, the filing contains a sworn declaration from her own attorney stating that she initiated contact with the special counsel's office. Her lawyer reached out first, proposed cooperation, and negotiated the terms. No subpoena was issued and no threats were made. The proffer was entirely her voluntary decision. Federal courts apply a clear test for voluntariness. Was the witness threatened with charges for non-cooperation? Was their own potential criminal exposure leveraged as pressure? When the answer to both is no, and the witness approached prosecutors independently, the cooperation is deemed voluntary. Her attorney's sworn statement decisively refuted any claim of coercion. The third argument warned that permitting this testimony would create a dangerous precedent eroding marital privacy in future cases. But that precedent already exists. Spouses frequently testify in federal cases when they choose to do so. The Trammell ruling resolved this issue in 1980. In reality, the defense sought a unique exception based solely on the defendant's identity. The Supreme Court does not grant exceptions according to who a person is. The law applies equally to all. Thus, when the court issued its one-sentence denial with no dissents, it delivered a resounding message. The arguments were not merely weak, they were deemed frivolous. To prevail on an emergency appeal to the Supreme Court, a party must demonstrate serious, irreversible harm and a strong likelihood of success on the merits. This appeal satisfied neither requirement. Allowing testimony to be heard is simply how the justice system functions, and prevailing on the merits would have demanded overturning Trammell, a step no justice was prepared to take. With the Supreme Court appeal denied, the grand jury can now hear her testimony in the coming days. The grand jury in this matter convenes on Tuesdays and Thursdays, consistent with standard practice in the Southern District of New York, where the case is proceeding. If prosecutors are prepared, and the proffer indicates they are, she could testify before the grand jury within the next 7 days, potentially as soon as the upcoming Tuesday. Once her testimony concludes, prosecutors will face a key strategic decision between two paths. The first is to leverage her testimony to bolster the existing charges. The current indictment contains 34 counts of falsifying business records and bank fraud. Her accounts of signing joint tax returns, participating in meetings with accountants, and corroborating other witnesses would significantly reinforce those already filed charges. The second option is to pursue a superseding indictment, introducing new charges supported by the fresh evidence she supplies. One detail to monitor closely is a March 2020 conversation she references in the proffer. She states she was present during a phone call between the defendant and a banker, where property values were discussed ahead of a loan application. If that discussion involved both of them jointly making false statements, with him asserting one value and her confirming it despite both knowing it was untrue, that constitutes conspiracy to commit bank fraud. Conspiracy is a distinct crime from fraud itself. It requires an agreement between two or more people to commit an unlawful act, along with at least one concrete step toward carrying it out. A phone call in which both parties knowingly lie to a bank constitutes the agreement. Submitting the loan application serves as that concrete step. If prosecutors are confident they can prove conspiracy through her testimony, they will pursue additional charges. A superseding indictment would introduce new counts and could dramatically increase the defendant's legal exposure. The trial remains scheduled for September 16th, which is 28 weeks away. With the Supreme Court appeal denied, no further delay tactics remain available, no more emergency motions to block evidence, and no more privilege claims to debate. That trial date will stand firm. This case establishes 3 precedents that could shape federal prosecutions for decades. The first is spousal cooperation at the highest levels of power. Spouses have cooperated in organized crime cases before. In the 1980s, prosecutors depended on wives testifying against husbands in mob trials. Sammy Gravano's wife cooperated, as did Henry Hill's wife in the case that inspired the movie Goodfellas. Spouses have also come forward in corporate fraud cases. During the Enron prosecutions, several executive spouses testified. Yet no one has witnessed this at the presidential level, where the spouse of someone who held the highest office steps forward with financial records, communications, and testimony that directly implicates them in federal crimes. This truly changes the game for future investigations. When a federal prosecutor is building a case against a powerful official and knows the spouse shares legal exposure, perhaps because they signed documents or attended key meetings, they now have Supreme Court precedent confirming that spousal privilege cannot block voluntary cooperation. The second precedent is that the Supreme Court's swift response sends a clear message. Privilege claims will not be permitted to delay federal cases. The one-sentence rejection, with 0 dissents, has set a firm standard. When spousal privilege is voluntarily waived, emergency appeals grounded in marital privacy will not succeed. Courts will refuse to allow delay tactics disguised as constitutional arguments. This holds significant weight for every future white-collar crime case where spouses share financial exposure. Defense lawyers now understand that privilege claims will not serve as an effective strategy to buy time when the witness has chosen to cooperate. The third precedent is that accountability applies regardless of how wealthy or powerful someone may be. For decades, affluent defendants have relied on procedural maneuvers, endless appeals, privilege claims, and emergency motions in hopes of outlasting prosecutors or awaiting political shifts. This case demonstrates that the system can still function effectively when courts act decisively. The judge enforced a strict schedule. The Supreme Court unanimously rejected delay tactics. The grand jury process proceeded without interruption. The court said no. The judge said no. The law was applied equally, and the system worked because the institutions stood firm. Over the next 30 days, 3 specific developments will reveal the prosecution's strategy. The first is grand jury activity. If new witnesses are subpoenaed within 2 weeks, it signals that prosecutors are moving toward additional charges. The pattern of new witnesses and subpoenas will tell the full story, since more witnesses typically mean more counts. The second is the defense team's response. They will almost certainly file a motion to exclude her testimony. That is standard procedure. What truly matters is their focus. If they challenge the recordings, it indicates the recordings are damaging. If they attack her credibility, it suggests the documents are strong. Defense motions often reveal precisely what the prosecution's strongest evidence is. The third is whether the immunity agreement is finalized. The proffer is merely the initial step. Full immunity requires a signed cooperation agreement, a formal contract that clearly outlines the required testimony and the protections granted in exchange. When that document is filed, it will disclose the complete terms, whether she receives full immunity, partial immunity, or use immunity, which only safeguards the testimony itself from being used against her. The Supreme Court issued no opinion because the law was already settled. Spousal privilege can be waived. Evidence will be heard. No one is above the law, not because of wealth, not because of privilege, and not through endless appeals. The system worked because the courts adhered to established precedent.